Attorney Nouvelle Gonzalo here with Gonzalo Law, offices Gainesville, Florida, Miami, Florida, and Cleveland, Ohio. And today I want to take a moment to talk with you about a new change in the law that happened recently that affects employers and employees with their employer agreements. So if you work in the private sector, this is going to apply to you. And private sector is basically all work that is not part of the government sector. So you'll want to listen up. The National Labor Relations Board, or the NLRB, recently passed a new law as of February of 2023. And you might say, okay, but who is that? So the NLRB, great question, is the U.S. federal agency that's been put in place to help protect employee rights in the workplace with private sector employers. So this new law affects you whether or not you're an employee or an employer. You're going to want to pay attention to those changes. And these are changes that affect two types of clauses in employer-employee separation agreements. So the first clause is a confidentiality clause, and the second is a non-disparagement clause. I'd say, okay, sounds good. Can you remind me once more what a confidentiality clause is? Absolutely. So a confidentiality clause is a clause in an employee agreement, or any agreement really, that focuses specifically on restricting an employee's right to talk about workplace conditions, the terms of termination, or any employer trade secrets. And then a non-disparagement clause is another type of clause, and this is a paragraph in an employee contract that restricts an employee's right to speak negatively about an employer after they have left their employ. And so these are two big changes that have occurred because the NLRB has said that as a protection to employees, that employers can no longer require in their confidentiality clauses that an employee cannot speak about the workplace conditions, and they cannot speak about the terms of their separation or termination from the employer, that is no longer permitted as a condition of leaving or terminating an employer. They can still keep quiet about employer trade secrets, but not the other things. And then the other clause is the non-disparagement clause. The NLRB has also said that an employer cannot prevent an employee from speaking negatively about their former workplace, because this places a restriction on the freedom of speech that we all have as an American. So you'll want to check your specific jurisdictions, but because this is a change from a federal agency, it's likely to have impacts in all jurisdictions, but check with yours specifically. I'm speaking from Florida and Ohio in particularly. So you might say, okay, why should I care about this and why is it important? Well, if you're an employer, you'll want to care about this because you will want to review through your contracts and make the necessary changes and updates to your agreements to make sure that they're compliant with this new law that has come down. And then if you're an employee and you feel that maybe your employer hasn't done everything that they were supposed to do in the right way, and you had wanted to report this or talk about this, you want to take a look at your agreements to make sure that you're not being restricted from doing this. This is super important for us as law firms because as a corporate law firm, we draft lots of agreements for our clients that are ownership agreements, company agreements, employment agreements, and so it's very important to know about these changes and updates in the law. So wanted to share that with you. All right, well, stay informed and stay ahead and have an amazing day. Take care.